Hi everyone, welcome back. Today, with respect to Industrial Dispute Act, we are going to discuss on retrenchment. Retrenchment is defined in Section 2, Subclause OO of the Act. Retrenchment was not defined in the earlier statute, that is, Trade Dispute Act of 1929. The definition was inserted by the amendment in 1953. Retrenchment means to end, conclude, or cease, and that was defined in State Bank of India versus Sundaramani. In State Bank of India versus Sundaramani, 1976, retrenchment was defined that retrenchment means to end, conclude, or cease. Retrenchment is defined as the termination of the service of a workman for any reason whatsoever otherwise than by way of punishment. The definition leads to the conclusion that retrenchment is adopted to discharge surplus staff. According to Hari Prasad's case, that is AIR 1957, it means the discharge of surplus labor and is done with a motive of economy. The following is not retrenchment, that is 1. Voluntary retirement of the workman, or 2. Retirement on reaching the age of superannuation based upon the contract of employment, or 3. Termination on the ground of continued ill health. The expression for any reason whatsoever are the key words. Every termination spells retrenchment, but it must not cast a stigma as far as the workman is concerned. The employer must act in good faith. Now, in BC and G Mills versus Shambhunath, that is 1978, BC and G Mills versus Shambhunath. Mr. Shambhunath was working as motion setter at the relevant time. The management abolished the post of motion setter. Accordingly, he was retrenched. The management offered another suitable post to him. He was found unfit for that job even after the extension of probation. Therefore, he was offered yet another job on the same wages. But Shambhunath did not accept the post. He requested the management to give him one more chance to show his efficiency. Management refused to comply with the request and his name was struck down from the roll. The question was whether the striking down of the name of Mr. Shambhunath amounted to punishment or retrenchment. It was held that it amounted to punishment. This matter was referred to the full bench of Supreme Court, and the full bench held that it amounted to retrenchment. Again, Supreme Court in H.D. Singh versus Reserve Bank of India 1985. H.D. Singh versus Reserve Bank of India 1985 held that striking of the name of a Tika Mazdoor from the rolls amounted to retrenchment. Now, continued ill health. Ill health means disease, physical defect or infirmity or unsoundness. In one case, the Supreme Court held that amoebic dysentery is not continued ill health, and that is Imperial Tobacco Company of India versus Etiraj. In Imperial Tobacco Company of India versus Etiraj, Supreme Court held that amoebic dysentery is not continued ill health. The court ruled that a person suffering from mental derangement was in continued ill health. The Supreme Court in Barsi Light Railway Company's case 1957, Barsi Light Railway Company's case 1957 held that the legislature, in using the expression any reason whatsoever, intended to show that it does not matter why the employer discharged the surplus if the other requirements of the definition are fulfilled. In Workman of Subong Tea Estate versus Subong Tea Estate 1964, in Workman of Subong Tea Estate versus Subong Tea Estate 1964, the court had pointed out that if the management action is motivated by an intention to victimize the workman, the action will not amount to retrenchment. Now, in Mohanlal versus Bharat Electronics Limited 1981, Mohanlal versus Bharat Electronics Limited 1981, here Supreme Court held that Section 25F applies only to retrenchment relating to a workman who has completed 1 year of continued service. Now, conditions to be fulfilled before retrenchment, that is discussed in Section 25F. So conditions to be fulfilled before retrenchment is discussed in section 25F. Here, if the workman has not less than 1 year continuous service, he shall not be retrenched until the following conditions are fulfilled. So, if the workman has not less than 1 year of continued service, so minimum 1 year continuous service should be there, then he shall not be retrenched until the following conditions are fulfilled. So, these are preconditions to retrenchment for a workman who has completed at least 1 year of continued service. Now, A. 1 month's notice in writing indicating the reason for retrenchment. B. If no notice is given, wages in lieu of such notice are paid. Then C. Retrenchment compensation must be paid, that is 15 days average pay for every completed year of service or any part thereof in excess of 6 months. Now, D. Notice must be given to appropriate government, and such notice must be given in the prescribed form as contained in Rule 76 of the Industrial Disputes Act, Central Rules of 1957. So, notice must be given to the appropriate government, and such notice must be made in the prescribed form, and the prescribed form is contained in Rule 76 of the Industrial Dispute Act, Central Rules of 1957. Now, procedure for retrenchment. Section 25G. Section 25G of the Industrial Dispute Act prescribes the procedure to be followed by the employer while effecting retrenchment. The well-recognized principle of retrenchment in industrial law is the first come, last go, or the last come, first go. So, this principle has been recognized in Section 25G of the Act. So, that is, the most senior people are left the last or retrenched the last. That is first come, last go, or last come. The recently joined people are retrenched the first. So, retrenchment is in surplus of labor. So, the last person to join will be retrenched first. Now, the following must be noted, that is 1. He must be a workman within the meaning of the Act. Then 2. He must be a citizen of India. Then 3. He must be employed in an establishment which is an industry. And 4th, he must be working in a category under the industry. If the above conditions are fulfilled, the employer must ordinarily retrench the workman on the basis of first come, last go rule. So, for illustration, suppose in an industry there are 100 workmen. Employer intends to retrench 5 persons. The 100 persons must be retrenched. The 100th person who joined must be retrenched first, then the 99th, and so on. The word ordinarily means the first come, last go rule is not an absolute one. In case of any departure from the rule, the employer must state the reason, like special knowledge or training, or his services are indispensable for the industry, etc. The management can bona fidely retain the employees possessing special qualification whose services are indispensable in the interest of business irrespective of their seniority, and that was held in OM Oil and Oilseeds Exchange Limited versus Workman. So, in OM Oil and Oilseeds Exchange Limited versus Workman, it was held that the first come last go rule is not an absolute one. If the industry wants to retain an employee with special knowledge or skill for the benefit of the industry, then they can do so. That was held in OM Oil and Oilseeds Exchange Limited versus Workman. Only that this such reasons should be stated. Then in Swadeshi Mitram Limited versus Workman 1960, Swadeshi Mitram Limited versus Workman 1960, the Supreme Court ruled that even a senior employee can be retrenched against the principle if there is sufficient recorded evidence of his inefficiency or irregularity. Now, for the purpose of the deviation from the rule, employer must state the reasons in writing. The reasons must be valid reasons. According to the Supreme Court, the reason must be sound, sufficient, and valid. If the reason is invalid, the tribunal can set aside the retrenchment. The tribunal has to determine whether the reasons are fair, proper, and without any ulterior motive. In Workman versus Municipal Corporation of Delhi 1989. In Workman versus Municipal Corporation of Delhi 1989, the Delhi High Court had pointed out that Section 25F is applicable to a daily rated workman also. The Kerala High Court in Eranallur Service Cooperative Bank versus Labour Court, Eranallur Service Cooperative Bank versus Labour Court 1986, held that Section 25F is not applicable to termination of the service of an employee whose appointment is tainted with illegality. In Hari Mohan Rastogi versus Labour Court 1989, Hari Mohan Rastogi versus Labour Court 1989, the services of a town in charge was terminated. He was re-employed in another post even after 11 months. It was held that termination of service will constitute retrenchment, and that as the condition precedent to retrenchment had not been fulfilled, the retrenchment was invalid. It was further held that the employees would be deemed to be in service as town in charge of UP Electricity Board without any break. In Parry and Co. Limited versus VC Pal, here, judge of the Second Industrial Tribunal, it was held that in Parry and Company Limited versus VC Pal, judge of Second Industrial Tribunal, that is 1970 case. Parry and Company Limited versus VC Pal, judge of the Second Industrial Tribunal, 1970. Here it was held that the employer can bona fide recognize his business, resulting in retrenchment provided he pays compensation. In SP Bhandari versus Union of India 1986, in SP Bhandari versus Union of India 1986, the Supreme Court had pointed out that when a workman retrenched on the ground of surplus age was the only senior to be singled out and was redeployed to a post carrying lesser wages, the denial of relief of continuation in service on the plea that the workman did not accept the job offered to him was unjustifiable. So, remedy for illegal retrenchment. A workman who is improperly retrenched has a right to be reinstated in the same category with back wages and all other service benefits. Re-employment of retrenchment workman. According to Section 25H, it is mandatory on the part of the employer to give the retrenched workman an opportunity to join in the subsequent vacancy. The court in Industrial Hume Pipe Company Limited, Baliram and Gujbhai. The court in Industrial Hume Pipe Company Limited versus Baliram and Gujbhaya, that is 1965, expressed the view that a retrenched workman has no right to secure re-employment on his previous service terms and conditions. Now, Chapter 5B. Chapter 5B of the Industrial Dispute Act was introduced in 1976. It is applicable to an industrial establishment in which not less than 100 employees were employed. That is 1982 amendment with respect to 21.884. Now is preceding 12 months. So, Chapter 5B of the ID Act was introduced in 1976. It is applicable to industrial establishment in which not less than 100 employees were employed. The following are the relevant rules. 1. No retrenchment is allowed when the workman has 1 or more years of continuous service without fulfillment of the following conditions. That is the preconditions for retrenchment. That is A. 3 months notice in writing must be served. Such notice is not necessary if the appointment was under a contract which specifies the date of termination. P. Retrenchment compensation must be paid. It is equivalent to 15 days average pay for every completed year of continuous service or any part in excess of 6 months. Now, C. A copy of the notice must be sent to the government, and D. Permission for retrenchment must be granted or refused by the government. Now, management of KSRTC Bangalore versus Borais, that is 1983 Supreme Court decision. Facts of the case: the corporation reunited certain persons on probation for 2 years, and the probation period could be extended. The employer terminated the service of certain employees at the end of 2 years and extended the probation period to some other employees. An industrial dispute developed. Here, the question of law was whether the termination of a probation can be brought within the meaning of Section 200 of the ID Act, that is retrenchment, A constitution bench of the Supreme Court in an earlier case, that is Hariprasad Shivashankar versus A.D. Divagar 1957. In that case, Supreme Court Constitution Bench had held that the expression will cover the retrenchment of the probationer too. In this case, that is KSRTC Bangalore versus Borais, 1983, here Supreme Court reasserted the earlier view. So the termination of service of a probationer would also amount to retrenchment, and therefore section 25F must be fulfilled. So that is with this session with respect to retrenchment in Industrial Dispute Act. Thank you. Thank you for listening. Like, comment and subscribe, and click that bell icon so that you get an update when I upload my next video or a podcast. Thank you.